friends because I'm hoping that this week that we are going to spend together, we will become friends. We are here for Magistrates Court practice this week. And before we start, let me introduce myself. I think that might help. My name is Donovan Pitt. I'm a practicing advocate in the Eastern Cape, Bishore and Umtata bars. I've been an advocate for 11 years now. And before I was an advocate, I practiced as an attorney for 6.5 years. I also worked as a forensic lawyer with a special investigating unit for another 6.5 years. Just before we start, just a few house rules. Let us try to keep our microphones and videos on mute at all relevant times, please. I don't really like this platform for purposes of lecturing, but we are here anyway, and we have to make the most of what we have. So please let us try to mute our microphones and videos at all times, especially break times. Someone's microphone is not muted. So let's try to keep our microphones and videos muted at all times. It also saves bandwidth and it doesn't interrupt with the session that we are busy with. It can be very distracting when there's a noise in the background. I have to stop midway through what I'm trying to explain to you because of that distraction. So if we want things to move smoothly, let's try to implement firstly that one. Secondly, let us use the chat function on this platform only for questions relating to the subject we are dealing with. If we are going to be sending messages that are not relevant on the chat, it's going to distract us and it's going to cost us time. So let's try to keep it for purposes of the subject we are dealing with at the time. I will not be reading from notes. All right, I'm not here to read notes to you. I'm here to make this experience as practical as possible for you so that you understand it better. You will have had this knowledge imparted to you in your studies at university. Now it's time to apply that in a practical manner. And so I would expect that all of you had received your subject material prior to today. And I'm going to let it slide for today. And I'm not going to expect you to have read, but to those who have read your notes in preparation for today's session, well done. We are going to get along very well. To those of you who have not read today, you are off the hook. But from tomorrow, I'm going to emphasize that everyone who's attending this class from tomorrow must have read the notes. Okay? This is not university anymore. We're not in high school. This is now real legal practice. Okay? And as lawyers, you must love reading and you must have read ahead for today's session. As I said earlier on, I've given you a free disclaimer for that for today only, but from tomorrow, I'd expect you all to hit the ground running so we can make some progress here. And I'd like to emphasize once again, I'm not going to read from notes. So please do not stop me at any stage and ask me, which page am I on? That is the purpose of asking you to prepare ahead of time so that you come here knowing the theory. And when I give you the practical explanation or description of whatever process we are discussing, you should know what I'm talking about. Okay, any questions at this stage before we commence?
Good evening, Advocate. Can you hear me?
Good evening, I can hear you, yes.
I just have two requests. We have a standing arrangement in our class that all questions be jotted down and kept until the end to avoid sort of just making the process a bit drawn out. So can we just have that arrangement as well in this class?
Yes, I actually prefer that. I prefer that you write the questions down. If you have any questions, write them down. I'm not going to look at the chat during my sessions because it's distracting to me, and I'm sure you can appreciate that. So write your questions down as we go along, and then somewhere just before 7, because I intend to take a break at 7 o'clock for about 15 minutes. And so just before 7, say 10 to 7, I will give you an opportunity to ask your questions.
Great, thank you. And then my second request is just, I have a Drive document with a couple of past papers for court procedures saved. Would you mind terribly if I uploaded that Drive document to the chat so that we could maybe at the end of each session just work through a past paper so you can give us an idea of how you would answer the questions?
The notes contain self-assessment questions at the end of each module. I think that'll be
I'm sorry,
sufficient.
Advocate, that's with regards to board exams.
No, I'm sorry, I'm not dealing with board exams. I'm dealing with the notes as the subject that we're teaching, that we're doing this week.
Okay, no problem. Thank you.
Pleasure. Anybody else? Speak now or forever hold your peace. Okay. Thank you. Right. We are dealing with magistrates court practice. And that in itself should tell you that there are other courts. Magistrates court is considered to be your lowest court, actually. Not that what is done at magistrates is not important. It's very important, just like any other court. Magistrates are given the authority of all the same authority as all the other courts, although they may differ in terms of jurisdiction and the types of cases that are referred to the magistrates court. Right, now why do you need to do magistrates court practice? Because that is the primary court where attorneys cut their teeth. You will find that that is where attorneys feel comfortable, because you don't necessarily need to brief an advocate to appear in a magistrate's court. Although some attorneys do brief advocates to appear in complicated, complex matters in the magistrate's court. We have to always be mindful of our ethics as legal practitioners. And ethics play a vital role on an everyday basis. You have to, in this profession, always watch your back. Always make sure that you cover yourself in any event when dealing with your clients. Because believe me, one day there will be a client that's going to want to report you to the Legal Practice Council for having done one thing or the other, or failed to do something. And that's why it's important for you at all times to write down everything when you are dealing with your clients. You cannot commit everything to memory because you'll be dealing with many files at a time, and you won't remember what happened in a specific file because your memory simply does not have that capacity. So first rule is write everything down. Write everything down. You don't want the Legal Practice Council calling you to order or to attend a disciplinary hearing for some sort of professional misconduct. So at all times, be mindful of anything that can go wrong. Your relationship with your clients as an attorney now, I'm talking to you as attorneys, and hopefully some of you, most of you, if not all of you, will become attorneys after this. You need to know that your relationship with your client is a very sacred relationship. You are to treat all your clients with the same measure of importance. No client should be treated better or worse than another client. You've heard the saying, don't judge a book by its cover. The same applies to your clients. When dealing with your clients, give them your utmost attention at all times. After all, it is that very same client that you are going to expect to pay you for your services. And when you expect your client to pay you for your services, you expect them to pay you 100% of your fees and not a certain percentage. And that is why you need to give them 100% of your attention when you are dealing with your clients. So remember at all times the purpose of your client. The client is the reason for your office being open, and you need to give your client That was a classic example of why I asked you to make sure that your videos and your mics are muted at all times. It's distracting, as you've just witnessed now. Vincent, can I please ask you to be mindful of your microphone and your video? You don't have to respond now. Thank you. Right, now, when you are dealing with many clients, and you will be dealing with many different clients, you will be required to make sure that you handle each client's case meticulously with the minute detail that it requires. And when you do that, in order for you to be able to do that successfully, you will need to have a proper file administration process in your office. Now, what is a proper file administration? A proper file administration is some firms will use expensive lever arch folders, especially the ones with big clients that have a lot of paperwork. But most firms deal with what is called a manila folder. It's just bigger than an A4 size, folded in half, so that A4 paper fits inside it. Then every copy of correspondence is kept inside that file. Every copy of pleadings and notices is kept inside that file. And every copy of affidavits and all other affidavits is kept in that file. Take note, I said is kept because I qualified the word copy in the beginning and not the affidavits or the pleadings. So I am still using proper English. So you need to then, when you have that file open, and those of you who are already doing articles in firms will know that you are required to then identify that file with a unique reference number. So you will devise or design a referencing system in your office that will work for you. Either you use the surname of your clients as a letter with numbers 0001, and the next file will be 0002. You can either use it in terms of the alphabet or the numerical system, whatever works for you, but it must be something that can be implemented with ease in your office together with your other staff members. And this is before electronics. I don't know if it's still done now, but I come from a school where before emails, we practiced law, and everything that happened was handwritten. Yes, we had faxes back then too. That was the closest thing to an email. And you send the fax off, but you would make sure you keep the transmission slip as well as the actual fax in your file as proof that you've sent it off. Similarly so with regards to a letter which had to be sent to somewhere, the registrar's office, your opponents in a case, you still had to keep a copy of that letter on file as proof that you've sent it. Yes, I know things are electronically done nowadays, but electronic devices crash. And I still believe in the physical handling of paperwork. A physical brief or file that contains the pleadings as well as the notices in my brief or in my file. You will, when you start practicing, you will devise a method that is going to work for you at that time, at that appropriate time. Right, now we come to when you first consult with your client. You must remember your client is a human being, hopefully it will be, a human being who will come to your office and will make, and to come and consult with you. Now, it sounds very simple, but it's not actually that simple, because before that client can consult with you, there are a number of things that need to happen. First of all, that client must have made an appointment to come and see you. And that means that client must have phoned your offices to make that appointment. But before your client even phoned, you must have, as a legal practitioner, decided what type of work you are going to do or which types of cases you are going to do. Not everyone does everything, but you must decide, you must have decided when you open your doors for business, which type of cases you are going to do, because it's not going to help very much if your secretary answers that phone or your receptionist answers that phone when the client phones, and only to find that you're not able to assist the client because you don't do that type of work, which means that your receptionist or your secretary must know which type of cases you handle or you accept, so that that secretary or receptionist, when the client phones, is able to ask that client, what type of matter is it? That's very important. Somebody does not just pick up the phone and phone an attorney's office and says, I would like to make an appointment to come and see your attorney. And the person on the other side is not. The person on the other side of the phone. Now there's another demonstration of how distracting it is, guys. Come on. I've asked you so nicely. Make sure that your microphone and your video are on mute. Please, please, pretty please. That was the second distraction already. Your secretary or your receptionist must know what type of work you do, so that they can ask the person what type of case is it that you would like to speak to our attorney about. And when they tell you what type of case it is, then your receptionist or secretary is able to tell the client who called whether you do those cases or not. And then your receptionist or your secretary must also be trained to ask more questions. Before I book an appointment for you, can you please tell me, give me just a brief summary of what the case is about? Now, some clients will even think that's a nosy secretary or a receptionist, but it's not. And that is how you should train your secretary or your receptionist to ask those relevant questions, so that by the time the client comes to consult with you, the attorney, you will have read up on the law regarding that particular legal principle. So you might sound a bit more intelligent to your client when they walk in, but it will also tell your client that you value their work so much and that you care so much about pleasing them that you've done extra work before they've even come to you. So you're not only impressing your client, but you're also empowering yourself with the knowledge to be able to give your client proper advice going forward. Now, after that has happened, your client will now come to your office on the day and at the time of the appointment to actually consult with you, to tell you what their problem is. And when that client walks into your office, he or she is very anxious, is very stressed out. And these are the signs that you must pick up. And even if you don't pick up those signs from them, you must realize it in your mind already. Put yourself in that client's shoes. How would you feel if you had this problem? Nobody enjoys going to an attorney's office, unless you're coming to collect money. But nobody enjoys going to the attorney's office. It's like going to a dentist. You know you need help, but you don't want to be there. So you, the attorney, must make sure that you always have in mind your client's stresses, your client's anxiety. And that is all the more reason why you should give them 100% of your attention. When you consult with your client, you will consult with them either in a boardroom or in the privacy of your office behind a closed door. Behind a closed door, that's very important. There must be no distractions. No people must be able to walk in and out of your office whilst you are consulting. Make that clear to your secretary or your receptionist that you are not to be distracted. Excuse me. Your cell phone is a big distraction. Put it on mute, put it on switch it off, or give it to your secretary or your receptionist. And tell your receptionist or your secretary that you are not to be distracted whilst you are consulting. They must not put calls through to you. They must not put spouses or angry boyfriends or girlfriends through whilst you are consulting with your client. That is the importance which you must attach to your consultation with your client. You must treat them as if they are the most important people in the world. In fact, you must give your client the attention at that time as if they are the only person in the world, because you want to give them your full and utmost attention at all times. Now, whilst you have created that environment in order for you to consult with your client, you need to make sure that you apply one critical skill at all times. And that is the skill of listening. Listening intently to every single word that comes out of the mouth of your client. You do not speak while your client is speaking. You let your client do the talking. It is their story after all, not yours. You let your client speak without interrupting them. You let your client speak without completing their sentences. Because as lawyers, we have a tendency to finish people's sentences. Yes, I know some of you are nodding at yourselves right now, but that's just a habit that we've developed as lawyers. We like to finish people's sentences, but this is the one time where you do not finish a client's sentence. You do not speak while the client is speaking. You may stop your client to ask questions to clarify anything that they've said. Because if you finish your client's sentences or if you interrupt them while they're speaking, you will be doing that for the purpose of fashioning a course of action. And it's very tempting to do. I often have to stop myself from doing that too, because it's very tempting. Because already, whilst you are listening to your client's version of whatever happened, you are already in your mind fashioning a course of action. And then you think to yourself, whilst they are saying that, in order for the course of action to be complete, this is what they need to tell me. And then you finish the sentence for them. It's very tempting. And then they will also say yes, even though it may not be the truth. But some clients will actually go as far as saying yes, either because they are annoyed with what you are saying and they're just agreeing with what you are saying, but that could cost them in the end. But that is also your fault because you interrupted them. Okay. Now, and the same would apply to a witness that you are consulting with in your office. You will, if it's a witness, it's a different story, but you will apply the same principle as you do with your client. You give them carte blanche in the beginning to tell you everything that they need to know. And then thereafter, you may then coach them in the right direction as to what it is that you want them to say on the witness stand, if they are a witness of yours. So after your client has given you their version of facts and you are satisfied, you've asked all the questions, and I'll make an example. Your client talks about the events that happened on a specific day. Then you will stop that client, for instance, and say, Mr. Jones, you said you went there on this day. Is it correct? Yes, I did say that. All right. Now, can you remember what was the weather like on that day? Or do you remember what time you left home on that day? Or what time you arrived at your destination? Or what time did you first see the scene of the accident? Do you remember what the weather was like? And don't put suggestions to them. Was it rainy? Was it sunny? No, those are leading questions. You may not ask leading questions. You are not going to get the correct answers out of your client if you are asking leading questions. And as I said, with the listening skill, the same applies here. You want your client to give their story first, as fully as possible as they can give it to you. And only afterwards you can ask questions to clarify, but do not ask leading questions of your clients and your witnesses. Right, now, during that consultation, that first consultation with your client, it's very important, and this is most probably the most important thing, which I found over the years of practice. The issue of legal costs. The issue of legal costs is very, very important, if not the most important thing. You have to discuss with your client what you are going to charge them, how you are going to charge them, how you are going to invoice them, when you are going to invoice them, when they are going to pay you, how they are going to pay you, and of course, the most important question, have they got the money? As uncomfortable as that last question is, you have to ask it. You have to simply ask that question. And many times I've seen disagreements between attorneys and clients because they did not discuss the issue of fees. And I would even go as far as saying, draw up a fee agreement, make it standard practice. Make it standard practice for every single client that comes into your office. There must be a fee agreement, and it must be in writing. And there must be a clause attached to that fee agreement that says the client has read the contents of the fee agreement. It was discussed with the attorney and the client. The client accepts the terms and conditions proposed in the fee agreement by the attorney. And lastly, the attorney understands what is contained in the fee agreement. Because many times you'll find that clients, especially those ones who don't like to pay, oh, and believe me, there are many of them out there. There are many of them. The culture of non-payment is so bad that I think we need a special course just on how to manage your non-payments in your office. But never mind, we're not worried about that now. But it's important that fees are discussed from the very beginning of your consultation with your client. Even before you start taking down their statements or you listen to their story, you have to say, this is how we work as a matter of practice. This is how we deal with fees in this office. We have a standard fee, general fee, as a deposit. We are going to give you estimations of how much it's going to cost. I can't tell you that it's going to cost exactly this much. I'm going to give you an estimated figure. I'm going to give you my hourly rate as well as my daily rate. And then after that, we are going to draw up a fee agreement in terms of which you are going to tell me whether you can pay that or if you are not able to pay it. And if needs be, we can discuss other ways of you paying my fees. So that's important. You need to get that out of the way first before you even start consulting with that client. And your client will, when your client comes to you to consult with you the first time, it will either be because they need advice from you on legal papers that were served on them. So they are either a defendant in an action or they are a respondent in an application which has been brought by someone against them. They may also come to you because they want you to institute legal proceedings on their behalf against someone or persons. So those are the two most typical scenarios in which legal advice is sought or legal assistance is sought by a client from an attorney. You will then decide at that stage whether you can assist the client and how you are going to assist the client. And this is before you even take after you've taken the client's statement down from them. And when you consult with your client, also very important, at the beginning, I keep a digital device with me at all times, a recording device with me at all times. And I ask clients whether they would object to me recording the consultation. And the reason for asking them is because I say to them, in order for me to understand and capture fully everything that you are saying to me and that I don't miss anything. Oh, and by the way, I'm a very slow writer. I will not be able to write down everything. So I'm asking you for permission to record this consultation. Very, very seldom will they say no. I'm yet to have somebody say no. Because the moment you make them understand that the reason for you recording the consultation is so that you can capture everything that is being said to assist your client, then they will not hesitate whatsoever to give you permission to record. And that will also help them to watch their mouth, to count their words when they speak to you, because they know that it's being recorded. But let your client also know that when they step into your office, they are coming to you for help. And in order for you to help them, they have to tell you everything, absolutely everything. And everything that they tell you will stay within the four corners of that office. And it is protected by the right of privilege, legal privilege between an attorney and a client. And you as the attorney cannot simply divulge anything that's being discussed with your client during a consultation. Now, after you've consulted with your client, you may have captured his or her entire story during that first consultation. Well done to you if you're able to do that. But many a time you will find that your client has either not given you all the sufficient facts because they're not in possession of those facts. You then ask them to go and verify whatever you are not comfortable with or not happy with. You will also ask them for documentation, because documents are tangible evidence to use in litigation. Witnesses are very unreliable, by the way. Documents have a stronger evidential value than the testimony of a witness, because they are there. Witnesses change their stories. Today they will say one thing, tomorrow they'll say the exact opposite. So if your client is in possession or that knows where to find documentary proof in support of their case, ask them to get it. So you'll end your consultation by giving your client a list of the documents that they need, a list of the information that you need from them as well, so that they can go and look for it. And during that consultation, you will have also ascertained from your client as to who may be the possible witnesses to assist your client in their case. And he or she will give you the names of those witnesses. Ask them if that person, if they, in their view, that person will voluntarily testify on their behalf or in their favor. That's an important question, because if the person is a rude neighbor whom they don't get along with, but you need them as a witness, it's not going to be easy, maybe not even possible for that person to come and testify, unless you devise a strategy as to how you're going to get that person to come and testify on behalf of your client. Thank you. So it's important for you to make sure at all times that you know who your witnesses are. Your client must tell you who your witnesses are and whether they are reliable witnesses that will testify on behalf of and in favor of your client. Okay, I'm going to allow time now for questions, if any. Yes, whose hand is up? You may speak.
Good evening, Prof.
Good evening.
I just wanted to find out, how do we test the reliability of witnesses? Is there a standard like practice that's there, or do we just go on the word of our client?
Well, thanks for the question. Before you, when you meet with the witness, then only, and when you speak with that witness, then only are you able to find out if that is a credible witness. It will depend on whether the person is telling the truth, and you will know when they are telling the truth, because your client will be there. Your client has given you a version, and you will know what it is that you need to put to that witness. And if that witness does not give you satisfactory answers, you should know what your answers to. And by the way, a good lawyer always knows the answer to the question that it asks of a witness. So if you don't know what answer your witness is going to give you, don't ask the question. Have I answered you?
Yes, you have, Prof.
Thank you. It's advocate, not prof, but thanks for the promotion anyway. Right, next question.
Good evening, advocate.
Good evening, ma'am.
When does the subpoena work? Because you spoke about a rude neighbor. You referred to a rude neighbor. So can you subpoena that neighbor to come and testify, or is it only when it's in regards with the state?
Okay, can I say the following, please?
Okay.
You are all lawyers here, okay?
Yes.
I expect you to ask relevant questions of topics that I've dealt with. I've not spoken about subpoenas. I'm going to get to subpoenas when I deal with trials at the end of trial preparations, okay?
Okay.
So I don't want to confuse anybody now. We haven't dealt with subpoenas right now, but we will, when we deal with subpoenas, I will let you ask that question again, okay?
All right. All right. Thank you.
Thanks for your question though.
Okay.
Okay. Right, my favorite lawyers, because you are my favorite right now. Here is something that I want to give you now as a lawyer, and this is going to make you a very good lawyer if you follow this advice. Whenever you ask a question, make sure that the question is relevant to the topic we are dealing with. Okay? If you have looked at your notes, if you've looked at the notes that you've been given, you will see the topics are listed there respectively, you know, in order, in a particular order. And you will see which of the topics have subtopics dealing with particular questions. I prefer to deal with questions such as the last one that was asked by the last person when we get to that topic, because it's not relevant for now. It's going to be relevant when we've done everything else. Okay, but in order to get those witnesses to court, yes, you are going to have to subpoena them, and we are going to deal with the subpoena. I'm going to show you what a subpoena looks like too, so you can all see what a subpoena looks like. All right, another question. I know I've changed the rules. I said we'll have questions later on, but if anyone has questions now. Yes, Mr. Sakela.
Good evening, advocate. Sorry, I was on mute. I did not realize that I did not unmute properly.
Good evening, sir.
I'm just bringing us back to the question around reliability and credibility. Obviously, there's the sixth sense that we must operate with as lawyers to try and figure out if a person is telling the truth or they are lying. But what other things should we be looking at? For example, if it's a child that is a witness and obviously they were there and they saw the whole thing, but maybe because of them being a child, there's certain techniques that you must apply to actually get the full story from them. Or if it's a person who has mental issues or a drug addict, I don't know if the character of the witness has a bigger role to play when it comes to reliability and credibility. And I'm sure you might have dealt with some of those things. Practically, how do we navigate around that?
Okay, thank you for your question. The stage at which we are at now is dealing with the consultation with the client and possibly the witnesses thereafter, if there are any. And And you will be able to make the call after you have yourself consulted with those witnesses, because you are not going to come across those witnesses for the first time in court. These are your witnesses. These are your client's witnesses, and you need to prep them before, and you need to find out from them before what they actually know. And it's at that point when you consult with them that you will know whether they are going to be helpful witnesses or not.
Sorry, advocate. I'm actually at that stage of consultation before we head to court, because obviously at court I need to know their credibility. But I'm sitting here and I'm consulting with this person. Maybe my client is sitting next to me and I am asking the questions that I'm asking. But how do I get to that level of saying, okay, maybe this is a credible witness and reliable witness, just based on some of these curveballs that I'm throwing, being a child, a person with mental challenges, or like a drug addict that might actually affect the case. What are the practical, tangible things that I should look out for to say, okay, reliability and credibility is probably guaranteed should we move forward to trial?
Okay, thank you. Raquel, would you like to add something? Okay. All right. Now, I hear you. I was also at consultation stage. And the actual evidence that that witness will be required to provide will determine whether that person is relevant or credible. And firstly, let's come to relevance. Relevance in that, how important is this person's evidence for purposes of your client's case? And if it's not the only evidence or not the only witness that you need, you ask yourself, can I actually do without this witness? Somebody's mic is not muted. Can you please all check if your mics are muted? Is someone scratching in the glove compartment of a car looking for something, or a handbag? Now, if you ask yourself the question, is this person the most important witness for my client's case? Or is this the strongest witness that I will need? And if your answer is no, and that person is either a drug addict, an alcoholic, a mentally disturbed person, or a minor child, then you don't call that person as a witness. All those 4 people I've just mentioned now suffer from a severe defect in terms of legal standing. So it's going to be more difficult to get any court of law to accept the evidence of those types of witnesses. So before you subject those kinds of people to being cross-examined, because they will be cross-examined by your opponents, and they are not going to take it easy on them. You have to also ask the question, will these people, because of these defects, be able to stand up to vigorous cross-examination? And if the question is no, then you don't call them. Then you don't call them, unless they are the only witnesses to a case and you are sure that they are able to stand up to vigorous cross-examination. Then and only then do you use those persons. But where those types of vulnerable witnesses are used in cases, the court, the presiding officer, the magistrate in that case, will protect those people from brutal litigants or legal representatives. Because as much as they are doing their job by cross-examining those witnesses, you are only allow so much latitude towards witnesses in a court of law. Have I answered you, sir? And fully so.
You've answered me clearly and fully. Thank you very much.
Thank you for your question, sir. Mr. Sonwabile Xaba, your hand is up.
I just want to make a follow-up on this question in terms of a system.
Is this
there a
Sonwabile?
yes, it's Mrs.
My
Miss
apologies for
Sonwabile.
saying
Sorry.
this.
Now everyone calls me Mr. It's fine. So I just want to ask, is there a system where you can punch an ID of a person, in this case, maybe your clients or your witnesses, just to check, following up on that question that was raised, to check if the person was involved in drugs or the person is not, you know, a witness that you can rely on in terms of cross-questioning, you know, all those things? Is there a system where you can be able, at least also to protect yourself as an attorney?
No, you have to do
There
it the hard
isn't.
way. You have to do it the hard way. You have to ask those difficult questions. When it's either your witness, your client is going to tell you this person suffers from this, or this person is like this. And when you consult with that witness, you will notice certain tendencies that they have. Ask those questions. Are you going to be able to testify in a court of law? Yes. Now, remember, when you testify in a court of law, you will be cross-examined by our opponents. Do you think you will be able to stand up to that cross-examination without being shaken? Do you have any dependencies or any illnesses or conditions that stand in your way of testifying as a witness? And most importantly, you ask them, do you want to testify in this case? You can't force a witness to testify on your behalf if it is your witness, but you can compel another witness that is not your witness. And we will deal with the different types of witnesses later on. So, ma'am, to answer your question, no, there is nowhere that you can punch in names and numbers that will tell you that this is a credible witness, this is an incredible witness, this is a reliable witness, this is not a reliable witness. You just have to do it the hard way by actually consulting with that witness and determining. Another skill which you will develop as a lawyer is how to read people, is how to tell when people are telling the truth. And with your own witnesses and your own clients, you must be able to tell if your client is telling you the truth. And what I normally do with my clients, if I don't believe what they're saying, I normally say to them, I don't think the judge will believe this version. Can you perhaps try another version that the judge, I don't have a problem, I believe you, but the judge will not believe you because it's not probable. What do you think the judge will find as a probable version compared to what you've just told me now? Then you'll find in all cases where I've tried that, the client has done a complete backflip and given you what you want to hear. So it's up to you to control your clients and your witnesses at all times. Be bold, but also be respectful to them. Don't tell them they're lying. Tell them the court might not believe their version. Don't tell them that they are being evasive. Tell them that if they are going to do that in court, the judge might not like it. So there are different techniques that you can use to get your clients to toe the line and to tell you what it is that you want to hear. Okay, we are going to take 2 more questions. So, Ms. Xaba, have I answered your question? Are you satisfied?
Yes.
With
Yes, I'm satisfied. Thanks, Advocate.
Thank you. 2 more questions. Whose hand is up?
Sir Sipho.
Sipho, Mr. Mtambo, yes, sir.
Yes, yes, Advocate. Thanks, Advocate. I just want to know, the first consultation, is it fair to allocate time to it? Because I've seen some lawyers where they say the first consultation will be an hour, and any time after that will be at some pro rata. I mean, is it fair to, if you want to get a proper understanding of the client's issue, is it fair to put a time allocation to the first consultant, consultation?
All right, thank you. That's a good question.
Thank you.
The only person who will be prejudiced by that is you, the attorney.
Yes.
Because as an attorney, you are selling time. You are paid to listen to your clients. And
yes.
Most times, if not all times, remember I've told you that this person is stressed out, this person is anxious, they're terrified.
Yes.
A lot of things are going on with that person, and they've come to you, not just for legal advice. You must also give them comfort, give them counseling. You must manage their fears and their anxieties.
Yes.
You must be all of those things in one. And in order for you to be a good one, you must listen to every single word they say. Most of it may not be relevant, but listen anyway. They want to vent. Listen. They're going to pay you for it. After all, you are selling your time.
Yes, yes.
So limit them as far as possible when you can. When you see that they've gone too far off the beaten track and they're going nowhere slowly, just remind them in a nice way that can we come back to the case now, please? Or would you still like to go for a walkabout in the fields? Then when they've understood that concept, they'll come back and they'll tell you. But by all means, listen to your clients. Do not put a time frame to your consultations. You will be doing an injustice to your client and a disservice to yourself.
Yes, yes. No, thanks for that, advocate. Thank you.
Thank you for your question. Last question before we start again. Who's going to ask the last question? The big question.
Hello, can you hear me?
Hello, yes, I can barely hear you.
Good evening. Counsel, my question is also based on the consultation, especially the fee, because I've seen most attorneys, they will just say my first consultation is 3.5, but it does not matter the duration. So I just need clarity. Is that how it's supposed to be, or they're supposed to charge on their hourly rate?
Okay. Thanks for your question, ma'am. It's a question of choice. There's no hard and fast rule. Nobody tells you this is what you must charge and this is how you must apply it. Each one basically comes up with what they think is an arrangement that's going to work for their firm. This is my firm, this is what I say happens, and this is how it's going to happen. So there's no hard and fast rule as to how it's done. I know with most of the law firms that do contingency work, they normally, that goes for road accident fund and medical negligence cases and other cases as well, unlawful arrest and detention, malicious prosecution. In those cases, they normally say the first consultation is free. And it would not be, I don't know how those firms work, excuse me, but my advice to you is rather do not put a time frame to it, even if it is free. Don't put a time frame to it because you are not going to get every single thing out of your client. And be honest at all times. Be honest at all times. This used to be an honorable profession, but it is slowly becoming not so honorable. And we all have a role to play to make sure that we elevate this profession back to the honorable status that it used to enjoy. And the biggest complaint that judges have these days against and magistrates is a lack of ethics on behalf on the part of legal practitioners. No respect for legal practitioners in court, no respect for their colleagues. So it's something that we all need to work on. So do not ever be tempted to lie to the court. Believe me, they will find out if you are lying, and it's going to come back and bite you. You don't ever want to be caught lying to a colleague and it's important that you are collegial to your colleagues. If you don't like someone because of their character or their personality, that's fine between the two of you. But do not turn to underhand tactics of trying to take an order behind your client's back, your opponent's back, trying to sneak something past them without them knowing. That is unprofessional conduct and it's unethical. And I'm going to make you an example of what happened to me about 3 weeks ago. I was in court, although this is the High Court and we are dealing with magistrates court practice here, but the principle is the same. I had brought an urgent application on behalf of my clients as the applicants, and my opponent was an advocate from out of town. And because he had to travel from out of town on the same day as the case, he called me and said to me, I'm running a bit late. Will you please, when our matter's called and I'm not there yet, stand the matter down for, tell the judge I'm running a bit late and stand the matter down. I said, I will gladly do that because I understand. I've been there before. And I did that. But because we had stood our case down, it was on the unopposed motion court row. I'll explain to you what those are later. When my case had been called again at the end of the roll after about an hour of me speaking to my colleague, I had a medical emergency that I had to attend to. And I was at the hospital and I phoned him and I even sent him a message on his phone to tell him, please stand the matter down further. Tell the judge, I've just got an emergency. When I came back from my emergency, I rushed back to court and I phoned him on the way, but he didn't answer my calls. When I got to the judge's chambers, court had already adjourned. The judge told me what my colleague had done. He had tried to dismiss my application in my absence. After I had waited for him at his request, he didn't wait for me at my request. And the judge said to him, but your opponent was here in court this morning. He asked that we stood this matter down, and we stood it down for you. Now you don't want to stand the matter down for him. The judge said, I'm not going to do that. And the judge even told him, tomorrow you will have a problem with your case, or you'll be running late again like you were today, and your opponent agreed to wait for you, but you don't want to wait for him. And then I had sent a message to the judge as well before to tell the judge's secretary that, please inform your judge, I've got an emergency. Please stand the matter down and I'm on my way back. So when I came back, the judge told me everything. So do not ever try to shaft your opponents, your colleagues in court. Even if you don't like them, you don't have to like someone. But do not ever resort to unethical, unprofessional, unbecoming conduct. It is going to come back to bite you. And believe me, when you start doing that, you are going to keep on doing it over and over again. So don't even start. You have a duty as officers of the court to be truthful and to be of assistance to the court at all times. So just keep that in mind. Right. Moving on, since we've asked our last question. What I want to ask you is, when you are reading through your reading material, I want you to get hold of the rules in the Magistrates Court. We are dealing with the Act number 32 of 1944 as amended, as the enabling legislation for Magistrates Court practice. Excuse me. That act promulgated regulations, which are called the Rules of the Magistrates' Court, in terms of which the Magistrates' Court functions. The Magistrates' Court refers strictly to those rules. The High Court also has rules. The Labour Court also has its own rules. The Supreme Court of Appeal has its own rules. The Constitutional Court has rules too. So it's important when you are dealing with Magistrates' Court practice that you familiarize yourself with the rules relating to the Magistrates' Courts and the procedures therein. And make sure that you get the most updated rules, because they get amended from time to time, right? So the last rules will have come into operation, the amended rules will have come into operation on the 15th of October of 2010, right? And they've also been amended subsequent thereto. So when you download those rules, it must state the rules regulating the conduct of the proceedings of the Magistrates' Court of South Africa. You will have heard legal people talk about a letter of demand. A letter of demand is in most cases a friendly way of instituting legal proceedings without having to institute legal proceedings. Legal proceedings are instituted. There are instances in which it is not necessary to send a letter of demand. But there are also instances where it is a requirement for you to institute proceedings by way of a letter of demand. Without the letter of demand, you cannot issue summons. And your summons is normally your first document that initiates legal proceedings. You issue a summons against someone. But there are cases in which you cannot issue that summons against someone without having given them a letter of demand. And if you have not given them that letter of demand, your cause of action is incomplete. You have not met the requirements. So, and I'll make an example. All organs of state, government departments in other words, municipalities, provincial departments, and national departments of government have to be given notice of intention to institute legal proceedings by way of a written notice. There is a specific act of parliament, also called legislation, also called a statute, that specifically provides for the issuing of a notice of a letter of demand before proceedings are instituted. That act of parliament or legislation is referred to as the Institution of Legal Proceedings Against Certain Organs of State Act number 40 of 2002. And that notice in terms of Section 3 of that Act, must only be sent in the event of a debt. Now, a debt doesn't mean you owe me and I owe you, not that type of debt. A debt in terms of that Act means a claim for damages against an organ of state, be it by way of contract, be it by way of delict, or be it by way of any negligence resulting in a delict. That is only in that instance may you serve, or as the words are used in the Act, deliver a notice of intention to institute legal proceedings against the department concerned or the organ of state concerned. Where that letter of demand is not sent. Oh yes, and that letter of demand or notice, we call it a Section 3 notice or a letter of demand. Where that letter of demand is required in terms of the Act, it must be delivered within 6 months of the date of the cause of action arising. So if, let's say you are suing the Minister of Police for unlawful arrest and detention, and you were arrested on the 12th of June 2022. By the 11th of December 2022, which is the expiry of the 6 months, you must have sent or delivered your notice, your Section 3 notice or your letter of demand. If you have not done so, you are out of time. But it can be cured. You are not locked out of court entirely. It can be cured by bringing an application for condonation. But before you apply for condonation, the Act also says that you can ask your opponent to consent to you not having sent it within time. But it's very seldom that a defendant consents to that, because that's a defense in itself. You can raise it as a defense. They've not issued delivered their letter of demand within 6 months. Therefore, they must be shut out of court. So then they will have to give you that letter within 6 months. So if you don't consent to them doing it in writing, then they have to bring an application anyway. They then bring the application, and in the application, they must show good cause that they are entitled to, there's a good reason why they were not able to serve the letter within 6 months. And there are various reasons. Number one, he was incarcerated. He didn't have access to legal advice. He didn't know that he could sue the Minister of Police only after he consulted with his attorneys, only after his attorneys got a hold of the docket, only after the case was withdrawn or they were acquitted on all charges did they become aware that they have an actual claim against the minister. That has been held to be a good defense or a good cause when you've not complied with Section 3 of the Act. But in order for you to succeed with that condonation application, you need to prove or allege further facts. One of those facts is that the claim is not prescribed. In other words, the claim was brought within the 3-year period, so it hasn't prescribed yet, so it's still alive. That's one requirement. A second requirement is you must allege and prove that you have good prospects of success in the main case against the Minister of Police. It mustn't be a hopeless case. It must show that you've got good prospects of success. And lastly, you must in that application say, there is no reasonable prejudice to the Minister of Police in me, one, giving notice out of time, two, not giving any notice at all. So you can then, on those facts, apply for condonation. Okay? Then if you succeed with condonation, then your cause of action will be complete in terms of your summons and your particulars of claim. We will discuss summonses, the different types of summonses later on. Now, those are cases, that's one example of where it is compulsory for a plaintiff to deliver a letter of demand or a statutory notice to the defendant, where that defendant is an organ of state. Now, coming to another example. Another example of where demand is important or necessary or required or compulsory even is where there is an agreement in terms of the National Credit Act. Now, Section 129 of the National Credit Act has got various provisions and requirements for a plaintiff or a creditor to sue a defendant or a debtor. One of them must be that the person must be given 20 days within which to either approach a debt counselor to assist them with their debts. They must make arrangements for payment of the arrears amount in an acceptable manner. And there are all sorts of things that they must do within those 20 days. So it's very important that that Section 129 letter goes out to the debtor before the creditor can institute proceedings. And then it's normally the banks or creditors who litigate against debtors, loan sharks. So it's important to know in which cases you have to, absolutely have to, send out a demand before instituting legal proceedings. And where it is a requirement, such as in the first instance against the Minister of Police, that you must deliver a letter of demand, in your particulars of claim, when you do the summons, you must make the allegation that the plaintiff has complied with the requirements of Section 3 of Act 40 of 2002. On the 12th of August 2022, the plaintiff caused to be delivered to the National Commissioner, the Provincial Commissioner, and the Minister of Police a letter of demand in terms of Section 3 of the Act. Here is a copy of that letter and proof that it was delivered, annexed as A. Now, what is a letter of demand, you ask yourselves? A letter of demand is a letter in which the creditor will tell the debtor that you owe me money. This is how you owe me the money. I lent it to you on this date. It was in terms of a verbal agreement between the two of us. You borrowed 50,000 rands from me, and you undertook to repay me the 50,000 rands on the 21st of December 2022. You have failed, refused, and or neglected to pay me that money. As a result, I am making legal demand for it now. That is, if you do not pay this amount, if you do not pay my 50,000 rands by the 15th of July 2023, I will institute legal proceedings against you. I think that's pretty clear and straightforward. It is a demand. It is a demand, person asking for their money. It's simple what it is. And when you write these letters of demand, you need to make use of simple language, plain and simple language that will be understood by the person reading the document. It's my view that most disputes arising from the interpretation of wills and contracts are caused by the attorneys who drafted those documents. Because of the way those documents are drafted, the language used in there, for instance, a testator who was died after having made out a will drawn up by the attorney is not there to express his or her intention. Instead, the attorney is called to interpret what he or she had in mind when they drafted the will, which is wrong, which is absolutely wrong. We need to move away from using big words, legalese, Latin maxims, which are mostly used in the wrong context. So we need to bear in mind always who is our audience, who are we writing this for, and what do we aim to achieve by writing in this manner. So we understand each other as lawyers when we use our language, our legalese and our Latin maxims, especially over the weekend when we are chilling in a tavern or a pub. But when at the end of it all, when reality sets in, we have to remember it's our clients whom we serve, and they are the ones who need to actually understand our writing. We need to simplify it. We need to break it down for them. We need to make it understandable in an easier manner for our clients. But keep your writing formal. Use simple language, but try to keep it as formal as you can still. Okay. I'm going to give you 8 minutes for questions, and then we can take a short break. Heaven.
Hi, Advocate. I just wanted to find out, for legal proceedings that are instituted for the letters of demand, or in order for somebody to gain whatever they had lost or have not received from another party, will they be awarded with cost, or the judgment that will be given will just be whoever pay Heaven his money, and then that's it?
Well, it would depend on the circumstances, because if for instance, in cases where no demand was made, parties were not awarded their costs. There's case law where parties simply, before writing a letter of demand, it was not compulsory for a letter of demand, but they instituted costs against that person. And where you've not done that, you are not entitled to the costs. In some cases, it'll be found. But in most cases, you are entitled to the cost of the summons only, and maybe not the letter of demand. If you have not written a letter of demand, you're not entitled to those costs. So you're able to recover your cost for your letter of demand in your summons when you institute proceedings. Am I making sense?
Yes, you are. Thank you, Advocate.
Thank you. Next question.
Good evening, Advocate. Can you hear me?
Good evening. Yes, I can hear you.
Okay. I have a question regarding, let's say I borrow 500,000 from you.
I don't have that much money.
But you are not registered as a credit provider. Will you be able to still recover that money, or do you have to be registered?
Look, I'm not sure as to what the National Credit Regulator says. about, because if you are lending out money, are you in the business of lending money, or is it just a friendly arrangement between the two of you?
No, let's say we are friends and I borrow that amount of money from you.
You don't need to
And
register
then
each case.
it's a verbal agreement, and then I don't pay you back.
No, that's personal. There's no need for a national credit agreement there, unless the parties want to agree to it specifically. But because the person whom you are borrowing the money from is not a money lender by trade or business, there's no need for them to register as a credit provider in terms of the National Credit Act.
Okay, because I've read about it, and what I could see is that it will be unlawful then, or difficult to recover that money should you actually borrow it out without.
Not necessarily. Not necessarily. It won't be unlawful. It may just be difficult because the fact that they haven't paid you yet when they were required to is a red flag already. But you will be able to successfully sue that person where you've gone into agreement with that person. They don't have to be registered as a national credit provider because they are not a money lender. It's if you are into the business of lending money to other people. In this case, it's only you who borrowed the money from this person, and because they were nice and they liked you and they felt sorry for you, they decided to lend you the money because it was sitting there in their bank account and it had nothing to do, and they decided to help you.
Okay, thank you.
Pleasure. Any other questions? Yes, whose hand is up?
Advocate, I just wanted to say that there have been cases in the past where even if it's just a friendly relationship where a friend borrows money from another from their friend, the court has in some instances said that they do need to register as a credit provider to be able to provide to borrow the friend that kind of money. I just don't remember what exactly the amount is, but recently, because I think 2 years ago, so I did do consumer credit law, and there were a few cases where the court has said that you do need to register as a credit provider. I just don't remember which case it was.
Okay. If you are in the business of lending money to people, not so.
That was not the case. I think I'll just look for the case and send it within the WhatsApp group, but there were instances where they said that you do need to register, and in that particular case, the friend could not recover the money.
Okay. Well, we'll be glad if you can help us with that case, then we can see perhaps what it says. Okay. But my understanding is that if you are in the business of lending money to people, yes. I understood Lavona's question to be a once-off between friends.
Yes. I think the case also was along those lines where it was a once-off payment of money, borrowing money on a once-off basis rather than on an ongoing basis. But I'll look for the case and I'll send it to you. I'll just go through my consumer credit notes and send it in the chat.
They must have based their cause of action on the National Credit Act.
Yes, it was the National Credit Act.
And I think that's where they failed. They should not have referred it to the National Credit Act. They should have said this agreement is not subject to the National Credit Act and stated in their case the reasons for that.
Okay, that makes sense.
Once you bring in the National Credit Act, you are confined to argue it only on that principle.
Yes.
Yeah, not outside of that.
Okay. All right, thank you, Advocate.
Thank you. Yes, sir. Or ma'am, whose hand is up?
It's a Seth. I think that particular case we might need to look at the facts of the case, and you'll probably find something that alludes to interest. And when there's interest involved, obviously, then, it needs to be looked in that light. I think we saw one particular case, I can't remember, it might have been the law of enrichment, where they say that firstly, no particular individual can be enriched unlawfully. So if you pay my money, you better pay if you owe me money, you better pay my money. I think that's a principle. But then if I start charging interest for that, maybe as a loan shark, or I'm in the business of borrowing people money and charging interest, then obviously it has to be looked in with the lenses of the National Credit Act.
Okay, thank you. Look, the Prescribed Rate of Interest Act applies in terms of all debt. And even if you don't have an agreement in terms of the National Credit Act, you are entitled to charge legal interest, which I believe is in the region of 10% or 10.25% per annum. So if you get judgment against that person, are you entitled to legal interest? But whilst you're not entitled to legal interest, you cannot simply say you've charged interest where there's no agreement between the parties on that particular aspect of interest. But thank you. That was very useful information. Last question before I let you have your break. One more question.
Good evening, Advocate.
Good evening, sir.
Yes, I just want to find out in terms of a letter of demand. Suppose
Yes.
an employee wants to recover monies owed to him by the employer. Who would be the relevant person to address the letter of demand to? Would it be the HR department or the company's legal department?
Do you want free legal advice for money? Okay.
No, Prof. I'm just interested.
You direct it to the company. The company will be your defendant if you sue them. But your letter of demand normally goes to your general manager or your managing director or your CEO. If in the case of a municipality, for instance, it will be the municipal manager. The government department will be the MEC or the HOD. So it will depend. I don't think HR is relevant, and I don't think the legal department is relevant. Go straight for the CEO or the general manager or the managing director of the company.
All right. No, thank you, Advocate.
My pleasure, sir. All right, that was our last question then. I'm guessing that you would like to take a break now. Can we agree on a time, please? Okay, let me agree on a time. It's now 3 minutes past 7. Can we get back here at 20 past 7? Is that too long?
It's perfect.
Perfect. 20 past 7 then. Thank you. Right, we are back at 7:20 as agreed. Okay, we are going to now deal with jurisdiction. Sure, this is a word that you've heard before and that you've come across in your study of civil procedure. Fumani Mabuza, I notice your hand is up.
Oh, my apologies, Advocate. It was that time when I was posing my question.
Okay. Your arm must be tired by now. You can put it down. Thanks. All right, I see another hand. Thank you. Right, we're looking at jurisdiction now. Yes.
Oh, sorry, I wasn't sure if the connection wasn't working. Sorry, just a question on what we covered before, and I'm sorry to take you back. But with regards to the letter of demands, I wanted to understand the issue of the amount of time that we give someone to respond to a letter of demand. Is it prescriptive that we have a set 7 days, 14 days to respond, or we can sort of look at each case and determine whether what would be justified in the circumstances, the number of days that we can give when we're giving out a letter of demand? This is in the context of when it's not sort of prescribed in a legislation, for example, like having your National Credit Act, or when you're notifying a government entity.
Thank you for your question on tobacco. Right. Your answer lies in part of what you've said to me. You will gauge the situation. If it's someone who has been owing you money for 2 years and 11 months, you are not going to give that person 30 days because in 30 days time, your claim will prescribe against that person. So you want to say to that person, if you even have to, if you are not obliged to send them a letter of demand, you should just issue summons. But where you want to be so kind as to issue summons in that case, excuse me, you will want to say to them, pay it within 3 days, failing which I will issue summons against you. That is reasonable in the circumstances, considering that this person has been owing you this money for 2 years and 11 months. You have every right to demand it within 3 days. You can even say to them within 24 hours for that matter. So the circumstances will dictate as to how much time you give them. In terms of the Act 40, in terms of organs of state, it has to be 30 days. 30 days is a reasonable period within which that government, that organ of state, is able to investigate the facts surrounding that claim. And that is why that act specifically says 30 days, because 30 days is considered to be a reasonable period within which to investigate. That's actually the purpose of that letter of demand, is for them to be able to investigate and maybe not even need to litigate. They may come back and say within 30 days, all right, fine, you have a legitimate claim against us, but we believe the amount is not fair. Instead of the 4 million you are suing us for, we believe you're entitled to only 2 million rand. And here's an offer for 2 million rand, without even as much as a summons having been issued against that organ of state. So each circumstance will be dictated by the facts of that case. Each one will be judged on its own merits. I hope I've answered your question.
Yes, you have. Thank you very much.
Thank you. Right, now what is jurisdiction? What is jurisdiction? Hear a lot in the movies, especially the American movies. sheriff will over the radio say, he's now left the jurisdiction of this county and he's in another county. What does jurisdiction mean in our case? In our case, it means the competence that a court has to hear a case. Because not all cases can hear, not all courts can hear all cases. I'll make an example. The magistrates' court is divided into two divisions. The first is the district court, and the second is the regional court. The district court can hear cases with amounts up to 200,000 rands. The moment it goes over 200,000 rands, let's say 201,000 rands, up to a maximum of 400,000 rands, the regional court now has jurisdiction to hear that case. And the moment it goes over 400,000 rands, it has to go to the High Court. Then the regional court has no jurisdiction over that matter. Magistrates' courts, you will hear this many times in argument, that they are creatures of statute. They do not have inherent jurisdiction that the High Court has, as well as all other higher courts. And therefore, magistrates do not have a discretion. They are creatures of statute. Now, there are certain cases in which the district court will have exclusive jurisdiction and where the regional court will have exclusive jurisdiction. Previously, a divorce had to be instituted out of the High Court and the High Court only. But there's since been an amendment to provide an amendment to the Divorce Act as well as the Magistrates Courts Act to allow the regional court to become a court out of which married couples can institute divorce proceedings. So that part of the Magistrates Court, the regional court, has now been given jurisdiction to be able to hear and entertain cases involving divorces. Here are some examples. Actions in which is claimed the delivery or transfer of any movable property or immovable property which does not exceed in value the amount of that court. That court will have jurisdiction. If the property is under 200,000 rands, the district court will have jurisdiction for transfer, for delivery of transfer of that property. For instance, one of the heirs in an estate, or rather the heirs in an estate want to sell a property out of the estate to a person. If that property, if there's a problem legally with that, and there's a need to compel someone to do the transfer, if the property is less than 200,000 rand, the district court will have jurisdiction to grant such a claim. If the property is above 200,000 rand and under 400,000 rand, the regional court of the magistrates court will have jurisdiction to hear that case. Similarly so, where a party wants to bring an action to evict someone from premises or land, the Minister of Justice from time to time issues a government gazette with specific amounts which can be heard in the magistrates court. You need to familiarize yourself with those amounts. And the same would apply in terms of the 200,000 rands and the 400,000 rand for you to determine, is it either the district court or the regional court out of which you institute proceedings. Another example is an action for the determination of a right of way. Or a liquid document, a claim arising out of a liquid document. Now, what is a liquid document? A liquid document is a document in which is specified the amount in dispute, in question, not in dispute, in question. Because if it's in dispute, then it's not a liquid document. And an example would be an invoice. An invoice is an example of a liquid document. And you can bring an action out of the magistrates court, depending on the amount, of course, between 200,000 and 400,000 rand. So just keep those in mind at all times. The Matrimonial Property Act, I said earlier on divorces, and also it must not exceed the amount of the values, the certain values, 200 and the 400,000 rand. An application for liquidation in terms of the Closed Corporations Act. We know that the Closed Corporations Act was repealed by the New Companies Act, and closed corporations are actually done away with now in the New Companies Act, but they are still provided for because they are still allowed to trade. There are still certain closed corporations that are allowed to trade, and for purposes of that, the Closed Corporations Act is still in force for those closed corporations that are still in effect. But it was effectively repealed by the New Companies Act. So you need to look at that list of different types of jurisdictions that I looked at, different what they call them, the different causes of action in terms of that. Right. Now, when a party institutes proceedings out of a court and that party is successful, what normally happens is we use the term costs follow the cause. And if the party has been successful, in other words, the one who's won the case, is entitled to recover their legal costs from the loser. But there must be a specific order. The normal order is party and party costs. In other words, all costs incurred in litigating the matter. So you're only entitled to anything related to things that have come to court. You're not entitled to things like consultations with client to prepare witnesses and all of that. You're not entitled to that in terms of party and party costs. In terms of attorney and client costs, if you're awarded attorney and client costs, it means that you are able to recover everything from your opponent from the day that you went to consult with them. when you traveled to go to court, when you bought yourself lunch, when you were at court, because you were at court. Those are attorney and client costs all running up. Okay, maybe not with the exception of the lunch. Don't worry about the lunch. The lunch shouldn't form part of attorney and client costs. If a party institutes proceedings out of the High Court, but the amount in question falls within the jurisdiction of the Magistrates Court. Remember, the High Court has inherent jurisdiction, so it can hear cases which should have gone to the regional, to the Magistrates Court. But if a party decides to go to the High Court and succeeds there, the court may only award that party costs on a Magistrates Court scale, the appropriate scale. But it has happened that parties who instituted proceedings out of the High Court, irrespective of the amounts, were awarded High Court costs. So just be careful when you institute proceedings as to where you're entitled to get costs. Okay. You can bring applications for eviction in terms of the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, which is also referred to as PI. So PI is illegal occupants. Just think illegal, that's all. If you are illegally on the land or in the property, PI will apply. If it is residential property, not commercial property, PI doesn't apply to commercial property, only to residential property. You may bring that application out of the Magistrates Court. Okay, but normally the value of the property will also determine or dictate to you which court, out of which court you must bring such proceedings. Okay, now the other aspect that you need to look at, so you don't look in vacuum only at these things when you want to determine the jurisdiction of the court. Another principle that comes into play in terms of the Act now, Section 28 of the Act, is in respect of persons. And the cardinal rule is you always follow the defendant, where the defendant may be. For instance, if you were driving from Umtata to, or wait, let me make a more practical example. For those of you who don't know where these places are. You're driving from Bloemfontein to Joburg, right? And in Klerksdorp, you have an accident with a truck. The owner of the truck, the driver of the truck is at fault, and you want to now sue the trucking company. The trucking company is based in Cape Town. The accident occurred in Klerksdorp. How do you decide which court has jurisdiction? Excuse me. You may go, the safest option will be where the defendant is based, Cape Town. But it's not the only determining factor, but it's the safest that I would say. It's the safest. Go where the defendant is. Another factor, however, is that you may also, the court that has jurisdiction may also be the court where the cause of action occurred. Klerksdorp is where the collision occurred. And I know insurance companies like to use this as an exception or a special plea, that the court does not have jurisdiction. I had the pleasure or the displeasure of having to argue on behalf of an insurance company that the plaintiff didn't have jurisdiction. I mean, the court didn't have jurisdiction over the defendant because the defendant was based in Johannesburg. And the argument came down to, and my opponent was actually my article clerk. He was my article clerk about 20 years before that. In any event, we argued the case. He argued that the court has jurisdiction because If his client is to win this case, my clients will have to pay him, his client, in the place where the court is, because his bank account is held in that court, in that place. And for that reason, that court must have jurisdiction, because whatever money he's going to get is going to pay it into his bank account, which is held at that place. It was an absurd argument, and the magistrate agreed with me. He took it on appeal, and the Court of Appeal in the High Court also agreed with him. He took it further to the Supreme Court of Appeal, and the registrar kicked him out there. It didn't even go to the president of the Supreme Court of Appeal. The registrar himself issued an order saying that there are no prospects of success. So sometimes your clients will tell you to litigate. They may have the money to litigate, but principles cost money. But also be wary that your clients act on everything that you tell them. So make sure that at all times what you tell your clients is legally sound, is accurate, is true and correct at all times. And believe me, if you give them wrong advice and they follow that advice and something bad happens to them, they will remember you. Oh, they will remember you gave them wrong advice. So make sure that at all times you cover yourself. These things will come back to bite you if you don't do that. Always cover yourself. So it's important, and a good source of information when you are looking for a defendant as to where they reside or carry on business or anything of that nature is to go onto the internet. It's a wonderful tool. You see there the website of that company with all its addresses and everything. It even helps you with the description of the parties, because you sometimes don't know if it's a close corporation or PTY Ltd. You go onto their website, everything is right there. So it helps you to even draft your pleadings, and it's very good to do it with this exact same wording that they have on there. They can't dispute their own information. And the same applies to government departments. For instance, in applications in terms of PAIA, Promotion of Access to Information Act, all government departments are required by law to have a PAIA manual. And the PAIA manual tells you exactly how you must refer a request for information, for access to information. On their website, you will find that PAIA manual, and it will even tell you who the contact persons are, whom you must send it to, how you must send the request, when you must send the request, and what you must do subsequent thereto. So it's very simple. The information is all right there for you. You don't need to look very far. Okay. So another issue on jurisdiction when you are following the defendant or the respondent is where the cause of action arose wholly within that district or the region division. The example with Klerksdorp, the accident. Klerksdorp Magistrates Court may have jurisdiction because that is where the cause of action arose. The accident took place there. The cause of action arose there. So familiarize yourself for those terms. Cause of action. What is cause of action? The cause of complaint. The accident, the incident happened in Klerksdorp. So they will have jurisdiction. They may have jurisdiction. The Act also provides for a defendant who carries on business. Okay. Now, what is carries on business? What does that mean? Another example. The Road Accident Fund has as its main head office in Pretoria. But we know there are also branch offices in Cape Town, Durban, Pretoria. No, we already said Pretoria, Durban, East London, Bloemfontein. I think Kimberley also has one, the major centers. So the Road Accident Fund, although its registered offices are in Pretoria, it also carries on business in other centers. So you may decide to sue or cite the Road Accident Fund as a defendant in an action in another part of the country, either because they carry on business there or because the whole cause of action arose there. So you can go to the magistrate's court also for interdicts. What is an interdict? An interdict is an order prohibiting a positive action or a negative action or an omission by a party. That is an interdict. Compel a party to do something or to stop doing something. The magistrate's court has the jurisdiction to consider such applications as well, interdicts, right? And you have to know what the requirements of an interdict are. There are two types of interdicts. One is an interim interdict, which is normally sought in urgent applications. And the other one is a final interdict. And there's a distinct difference between the two in that you have to meet certain requirements. You have to allege those requirements in your founding papers, and you have to say that you've met those requirements in order for you to get the relief that you want, be it an interim order or a final order. But you need not worry about those things for now. Just know that these are the types of things that you may bring in over which the court, High Court, the Magistrates Court has jurisdiction. Then there's something called mandament van spolie. That's a Dutch phrase referring to spoliation. In other words, the unlawful and wrongful dispossession of a party to a thing that was in their possession whilst they were in free and undisturbed possession thereof. Then the basis of spoliation or mandament van spolie is that no person may be unlawfully deprived of a thing. No person may take the law into their own hands. If your mother-in-law comes into your house, grabs your laptop and goes home with it, she has acted unlawfully. She may not do that in terms of the law, not lawfully so. So you have the right to go to court to say to the court, I want an urgent application, an urgent court order for spoliation. I've been spoliated. My mother-in-law took my laptop without a court order. She just came and dispossessed me of it. And under this legal principle, even a thief has a better right to something that is in his or her possession. You cannot simply go to a thief and say, this is mine, you took it away from me, and then you take it back from them. That is what the law is for. You go to court, you get a court order, you tell the court, that person has my possession, unlawfully obtained, I want it back. And I need the court to order that person to give it back to me. That's what spoliation is. You cannot resort to self-help by just going to take the thing away from the person. If a person resides elsewhere outside of the Republic of South Africa, let's say Botswana, but that person owns, or let's make it more interesting, Russia, the person's from Russia, but they own property in South Africa, lots of property. And you, because that person is not a South African citizen, the courts do not have jurisdiction over that person because they don't reside here. They don't have a permanent address here. However, they have property here. You then, if you want to sue them, if you want to establish jurisdiction, you go to the court where the property is situated. Then you, through that court, attach that property. Then you are creating a cause of action for yourself, and you are clothing that magistrate's court with jurisdiction over that person by your mere attachment of that property. Right, that's another way of establishing jurisdiction of the court. Section 45 of the Magistrates Courts Act also provides for jurisdiction by consent of parties. For instance, the accident that happened in Klerksdorp that I made an example of earlier. The person whose car was hit by the truck is from Johannesburg. The accident occurred in Klerksdorp, and the truck driver, the company of the truck, is from Cape Town. The plaintiff who is suing the truck company can say to the trucking company, listen, my friend, this is my very first time driving in this place, and it will probably be my last time. I will never leave Johannesburg again. Not because of this accident, but that was just a once-off. From now on, I live in Johannesburg. And man, you just killed my car. I don't even have a car anymore. So after this, I'm going to stay put in Johannesburg. And by the way, I'm unemployed. I'm a pensioner. I'm sickly. And I can't move around much. So I'm asking you to consent to the jurisdiction of Boksburg where I stay. Then the defendant can consent to the jurisdiction on that basis, because it's convenient for all the parties. If the defendant then insists that the plaintiff must go to Cape Town, which the plaintiff can do by refusing to consent to the jurisdiction of Boksburg, then that plaintiff will be severely prejudiced, especially after he's just explained his circumstances to the defendant. So, and parties in litigation don't always unreasonably withhold consent to something that will make the lives of everyone much easier. And the courts will take that into consideration if it should come out at a later stage. And then the court discovers that the defendant unreasonably withheld its consent. It's not going to come down on the defendant. That court is going to come down on the legal representative of the defendant for having refused to agree to the jurisdiction of the Boksburg Court, Magistrates Court. It's important to always seem like you want to assist the courts, reasonably so, and within the means and powers, capabilities of your client, of course. Not every piece of litigation has to be adversarial and, difficult. It doesn't have to be difficult. You can make it easier, and you can even settle a case where there was no need for a case to even go to court when you are open-minded and reasonable. In fact, the courts encourage parties at all times to try and settle cases And it's the job of the legal representative to steer your clients in the right direction. The court will visit you with its displeasure if it should find out that you've unnecessarily withheld information or consent or did not try to assist the other party at all. So be careful at all times, have an open mind and make sure that you try to meet each other halfway if it is possible. Sometimes we've got very difficult clients who make it impossible for us to try to reach any settlement whatsoever. But you need to guide your clients. Adverse court judgments have been delivered recently, in fact, where legal practitioners have not made the court's task easy, and the court has frowned upon them and has referred a few judgments to the Legal Practice Council for consideration of the professional conduct of those legal practitioners in question. So be careful that you don't become a statistic. The courts want you to litigate honestly and openly. There's a hand.
The conduct of professionals, of legal practitioners being unprofessional. In a case where you tell your client, look, we need to consent to this jurisdiction as agreed upon by parties, and he just blatantly refuses. He says, no, I don't see the purpose of this. They get to travel 5 kilometers every single day. I need to travel 15. And they're being so petty that they just blatantly refuse. Obviously, as a legal practitioner, you can't refuse instructions of your client, but what would one do in such a circumstance where the judge asks, Mr. So-and-so, why did you not consent to jurisdiction? And your only defense is, my client simply refused to. He feels it's unfair to travel 15 kilometers while the plaintiff travels 5 kilometers. What does one do in such an occasion? And the reason I'm asking is because I did face this in court, and I was flabbergasted by the question. So I'm just looking for advice.
Okay, good. No, thanks for that question, Janus. It makes complete sense. As a legal practitioner, you also have a duty to guide your client in the right direction. And one way of dealing with that would possibly be, look, the magistrate would not ask us to do something that we don't want to do. But in all fairness, if the magistrate must decide whether we must agree to consent to the jurisdiction or not, it's going to look at the circumstances of the other party. And if that party's circumstances favor us having to consent to the jurisdiction, then I think we better consider doing so. And if he doesn't want to, and then you also tell him that if the magistrate finds that our consent is being withheld unreasonably, then, and I've got a duty to tell him, and in this case, I do think that it's being withheld unreasonably, then we will be visited with the displeasure of the court, either by way of a cost order, which can be avoided. So in a subtle way, just lead your client in the right direction. I don't know if that's okay, Janus.
Yes, no, it is. Thank you very much, sir. That was the eventual outcome of that matter. So thank you very much.
Okay, thanks for the question. Is there another hand? Nontobeko Gosi.
Yes, thank you so much, Advocate. I wanted to ask on two things. So you see, when you give consent, right, as to like when you have a contract, for example, and then you give consent to a specific court, but then now this relates to high court and magistrate matters where the amount that is being claimed for is around 10,000 Rand. However, instead of the attorney then approaching the magistrate court, they then approach the high court for an order. They issue summons there. I think I just need to have a better understanding of why that normally happens. Because yes, I understand the concept of contracts like practice in Savanda, that this person wants to consent to you approaching the high court, granted, but looking at the value, how much is being claimed in that instance, it doesn't make sense for me why you would take a 10,000 rand matter to the High Court, and it's not a matter of distance. They might actually be a kilometer or 500 meters away from each other, the High Court and the Magistrate Courts. And then also, I'm not sure on this one if you can answer it now or at a later stage, but the part about costs as to a registrar acting in assisting in, let's say, for example, in default judgments, not awarding cost as to attorney and client because it's in the contract, the parties consented to that, but rather they want to give a party-to-party scale. What sort of can be done in that instance where there's a contract that stipulates how much should be on the scale that the parties have agreed to? Thank you.
Thank you for your questions, Ntobeko. Okay. I said earlier on that the High Court has inherent jurisdiction to hear cases that can be heard in the Magistrates Court as well. It is a question of choice. And the choice is mainly based on how deep your client's pockets are. If your client says, I've got the money, let's take them to the High Court. They're welcome to do that. Even if it's a 10,000 rand case, it may not make sense to you, but it may make sense to them. They will say, let's frustrate them. We know they don't have the muscle to go to the High Court. Let's go to the High Court. Hell, let's even get an advocate. Let's brief an advocate and knock the wind out of their sails. But those are not the things that you are going to disclose in court. The court doesn't know those things. But those are the things that you, as your client, will use and convince you to do it. And also, although I'm not supposed to say this, things work smoother in the High Court than they do in the Magistrates Court. You'll be frustrated in the Magistrates Court, and you just made a perfect example where if you apply for default judgment, you are given costs on a party and party scale, although there's a contract that awards you costs on an attorney and client scale. In the High Court, things just work better. In the High Court, there's no default judgment that's done by the registrar, only in certain cases, specific cases. But even there, when it comes to the issue of costs, and there's a contract that awards you attorney and client costs, and that request for default judgment goes to the clerk of court for that default judgment. Flag I would also even do short heads of argument, in which you point out this is an action for damages based on a contract. The damages are so much. The contract is found at page so-and-so of the papers, and you put a flag on the contract, the page that you want to bring to their attention, and you say, this is a request for default judgment of the judgment debt, together with interest on attorney and client scale. And then you say, attorney and client scale costs are provided for in the agreement between the parties, which is found at page so-and-so under paragraph or clause so-and-so. You will find that the clerk of court will grant you costs on an attorney and client scale in those requests for default judgment. I hope I've answered you, Ntobeko.
Yes, you have. Thank you very much.
My pleasure. Thank you for your question. All right, we've got, is there another hand up? If there is, I'll allow one more question.
Good evening, Advocate. My name is Sasha. Thank you so much for the indulgence. Advocate, I have two questions, and I'm not sure if it has been answered yet, but I need to just make sure that I do understand the issue of jurisdiction correctly. If, for example, you need to compel the transfer of a property in a certain jurisdiction, the property's value is, for example, 1.3 million, and I want to, and for example, the deed of sale, or the sales agreement states specifically that the magistrate's court in that jurisdiction has, should hear the matter or should entertain the matter. But now, obviously, the property's value is more than the magistrate's court jurisdiction. So where would you then institute it? Would you go on the sale, the contract, or would you go then on the value of the property?
Look, either way, Sasha, good evening. Yes, and thanks for your question. Either way, you've got the contract. The contract, in terms of the contract, both parties have agreed that the magistrate's court may have jurisdiction. And that is how you will term it in your papers. If it's an action that you're bringing, you will specify in there. It was an express term of the agreement, which is annexed here too, that the parties shall bring any action arising from this deed of transfer out of the magistrate's court. And on that basis, this court is vested with jurisdiction to hear this matter.
Okay, perfect. So then obviously that will also count if you would bring an interdict to stop the transfer of the property for specific reasons.
Well, the High Court has inherent jurisdiction. So if you have a question with jurisdiction, always go to the High Court.
Okay.
Yeah,
Okay.
If in doubt, go to the High Court.
Okay, perfect. Thank you so much, Advocate. I really appreciate it.
My pleasure, Sasha. All right, I see a flurry of hands now up. The debate is getting heated. I don't know whose hand was up first. I'm going to say Tsolofelo.
It was mine, Prof. Advocate, sorry.
Who is it?
It's Mikateko.
Mikateko. Okay, Mika, you may proceed.
Evening, Advocate. So I wanted to ask, I'm not sure if it was asked or not, because I struggled with a little bit of internet connection a little bit earlier on. So I wanted to find out, in terms of divorce matters being heard in a magistrate court, what would then, does basically a high court also have jurisdiction to hear a divorce matter? And what would constitute the, what do you call this? What would award or afford a high court the ability or the rights to hear that divorce proceedings, or it doesn't happen?
Okay, thanks, Mikateko, for your question. First of all, I said that divorce actions, the High Court had exclusive jurisdiction to hear divorces because it has to do with a person's status, right? Only the High Court had that jurisdiction. But recently, the regional court of the magistrate's court, not the district court, only the regional court, has been given jurisdiction to hear cases involving divorce, right? So the regional court of the magistrate's court can also divorce couples, but the amount of the value of the estate can be a determining factor. If the estate falls within the limit of the jurisdiction of the regional court, that is 400,000 rands, then you may bring a divorce action out of the regional court of the magistrate's court. Does it make sense?
Yes, it makes sense, Advocate, but I would like to ask, you're saying that if the proceeding, the estate of the client is more than 400,000, then it will move on to
the
High Court.
Yes.
So what happens in a case where the proceedings are it's more than 400,000, and then does it still, is it a must for it to go to High Court, or it can remain with the magistrate court?
It can remain in the magistrate's court by agreement between the parties.
Oh, so it's not a must. The amount is the only figure, basically the determining factor that will take the divorce matter to High Court, nothing else, only just the amount, if the parties agree.
Yes.
Okay, no, thank you so much. It makes sense now.
All right, Mikateko, pleasure. Number 3, that's number 3. Who's number 4? Tsolofelo.
Thank you, Advocate. Mika took my first question. At least I'm answered on that.
Okay.
Advocate, my second question is on the interdicts. You mentioned that we've got interim and final interdict, and I just wanted to find out, can we review an interim interdict?
Review?
Yeah.
No, because it's not a final order.
Okay.
You can only review a final order or appeal against the final order.
Okay.
Right.
Thank you.
Janus.
Thank you very much, Counsel. Just the last question. Does the Magistrates Court have the jurisdiction to transfer a matter from one Magistrates Court to another?
Transfer one matter from one Magistrates Court to another. A magistrate.
Yes, indeed, Counsel. So to give you an example, one other case that came to mind, the plaintiff instituted action proceedings in the court without the necessary jurisdiction. They tried transfer in terms of Rule 35, but the judgment at the end of the day was that they didn't have the necessary jurisdiction to be able to transfer matter from the Tshwane Central to the Brits Magistrates Court, for example. Is that the case?
Well, matters are transferred from one court to another by consent between the parties, right? And if not, then in terms of section, I think it's 46, the only person that may consent to the transfer of a matter is the defendant, not the plaintiff. If the plaintiff is in the wrong forum, then that's the plaintiff's fault. But the defendant has to consent, or may be the one asking the court to move a matter from one magistrate's court to another magistrate's court. Have I answered you?
Yes, absolutely, Counsel. Thank you very much.
Just have a look at section 46 of the Magistrates Courts Act. Tulufelo, I'm going to use my democratic powers of authoritarianism and ask you to please wait. I want to finish up to a certain section today, and we are left with about 28 minutes, well, 18 minutes left only. Is that all right?
Yes.
Okay, so you may ask your question. You may ask your question.
So now, Advocate, I just wanted more clarity to say, how would you advise if a person is still on the interim interdict? So this is a very interesting one. An executive authority goes to the newspapers and says, it's not the end of the world with this interdict, I am going to review. So how would you go about advising them in an opinion, you know, to say you can't? And what would be the other recourse? What must they wait for the final order? And then after that final order, then they can go and appeal or go for review.
Okay, I would normally say to you, you draw up a brief to me and I will do that opinion for you. I charge a very reasonable fee, but in your case, I will say the answer is the same. They have to wait for the finalization of the interim order and then see what happens. Because if it becomes opposed, like it most probably will from what I've heard you say, it will go to the opposed court, it will be argued, and then the court will then deliver judgment on that case. And then the parties will have to live with the order of the court, unless, of course, there's a party that's not happy. But it's up to you, the legal representative of that party, to convince them, to show them that the conclusion that the court reached is just and is fair in the circumstances based on the law and the legislation. Are you happy with that answer, Tsolo?
Okay. Yes, we will say brief.
Okay, I'll wait for that brief. Thank you. All right. Okay, just a few final things before I give you questions until 8:30. The Magistrates Court also now has jurisdiction to hear cases for the rendering of an account. For instance, you want to sue the municipality hasn't given you an account for your water and electricity. You can institute proceedings out of the Magistrates Court for that. And the debatement of that account, in other words, they must show you how that account was arrived at. You can bring that cause of action out of the Magistrates Court as well. You could not bring these cases to Magistrates Court before, but now the jurisdiction of the Magistrates Court has been expanded. And this is because the High Court roles have become so clogged with mundane cases which shouldn't go there. And the High Court will very quickly point out to you where they feel a case should not have come to them at all, and that you've wasted their time. So it's your job too, as an attorney, to guide your client in the right direction. If you think you can get this relief in the Magistrates Court as easy as you would get it in the High Court, rather opt for the Magistrates Court. And this is where good relationships come in. You won't see this in a book. Your clerk of the court, your court orderlies, the lady who sweeps the passages there at court, everyone whom you will encounter when you go to court at the Magistrates Court, you need those people. Be nice to them. Don't buy them Kentucky and Coca-Cola, okay? Don't give them money, because that just messes things up. But form a good relationship with them. Then you get things done. But as I said, don't bribe them. Don't do anything unlawful. You need those people. And you will find that if you have good relationships with them, things just go so much easier for you. You don't have to bribe people to get things done. So it makes life easier for you, and that it'll make it more pleasant for you when you go to court. Don't be late in court all the time. That magistrate will hate you. You'll be notoriously late and you will not be liked. Try to be early for court. And even so, when you are late for court, your client can lose their case. Your client can lose their house. They can lose their livelihood. They can lose their family. They can lose their job. They can lose their business. They can lose so much. All because you did not respect time. You did not go to court on time. That is very important. You can't allow that to happen. So at all times, make sure you have good relationships with people at courts. It'll make your life so much easier. Now, we spoke of the rendering of an account and made an example of the municipality, the debatement of that account. Now, for the payment of that account, it mustn't exceed 200,000 rands for you to be able to, for the jurisdiction to be applicable in the magistrate's district court. If that account which you want debated or delivered to you exceeds 200,000 rand, but not 400,000 rands, that is a regional court case jurisdictional competency. Know when those happen. All right. And you will, and there's in your notes, there is a nice chart which sets out the magistrates court, the exceptions to the 400,000 rand general rule. You'll see there's a comparison. Even if it's over 400,000, certain claims may be brought in the magistrates courts if there's consent. Also, if the court doesn't, if the amount is over 400,000 rand and you still want to institute proceedings out of the regional court, you may do so, and then you just abandon the other portion thereof. You'll say, so-and-so owes me 467,000 rand. This court's jurisdiction is 400,000 rand. I'm abandoning the 67,000 rand and I'm asking the court to give me judgment for 400,000 rand, which is within the competency of the magistrates court. You can do that, and you will be given that if you ask for it and the person doesn't have a defense. So know those and you'll be able to understand the issue of jurisdiction better. Right? We did say that the High Court has concurrent jurisdiction with the Magistrates Court, but remember the High Court also has inherent jurisdiction. So it's slightly higher in authority and it has more powers than the Magistrates Court. So in other words, cases of lower ranking, I would say, in terms of monetary value in the Magistrates Court, you can also bring in the High Court because the High Court has inherent jurisdiction. Only where a litigant, normally a defendant or a respondent, objects to the jurisdiction of the court will the court consider it. The court, however, may also mero motu on its own raise the issue of jurisdiction and tell you, even if your case is undefended, unopposed, but Miss so-and-so, I noticed that this case, this accident took place in Nelspruit, but you are instituting proceedings out of Boksburg. Does this court have jurisdiction? You have to convince the court. So the court, and this is another big tip. If your case, I sometimes wish that my cases are all defended or opposed, because the unopposed and the undefended cases are the most difficult ones. And why is that? Because your opponent will become that magistrate or that judge. They will quiz you. They will ask you questions as to why this and why that. So whenever you represent a client in an undefended case or an unopposed case, prepare as if it is defended or it is opposed, because you will be asked while standing on your feet, Mr. Pitt, can you please tell me if how this court has jurisdiction? And you go, because you thought you won't be asking for anything except for an order or a judgment in your favor. You need to prepare as if it is defended or opposed at all times. Never take for granted that your case is not opposed or defended. This is going to be easy, and you walk in there with a hangover from yesterday because you thought you've got this in the bag. It could get even worse than that. You might even lose your case without an opponent, because the judge will be your opponent or the magistrate will be your opponent. Right. Some questions. Okay, Louis, am I correct?
Donovan, good evening. Can you hear me?
Good evening. Yes, I can hear you.
Good evening. I have a quick question.
Yes, sir.
Spoliation application.
Yes.
Vehicle is under the auspices of, is the subject of a spoliation application. The vehicle's value is 60,000 Rand. Can it be brought in the magistrate's court?
Yes.
I thought so. No, I thought so. And then the other thing. Yeah, the other thing is quickly, thank you very much for a very, very, very nice presentation. I enjoyed every minute. Is a cell phone signal a thing subject to a spoliation application?
Okay, in answering that question, I'm going to refer you to a case against Eskom. Eskom had disconnected someone's electricity. They'd taken them off their electrical grid, and it was found that electrical services can be spoliated.
I'm aware of that case, and that's why I'm asking. I've got a case like that now. I shall actually brief you on that.
That'll be an interesting one, yes.
Yeah, thank you, Donovan.
So you say signal to a network.
Let me put you in the picture. A contract of sale or a rental contract says a signal is part of the rental contract to a certain area.
Right.
The rental parties, the parties have changed, and now with the new service provider,
Yes.
it is no longer a perk.
Okay.
I should actually send you a brief, but I want to bring a spoliation application to give the signal back.
That sounds like an interesting one. If a party has control over something, it can be spoliated.
Thank you for a very, very well done presentation. Have a good evening. Talk to you again.
My
Thank
pleasure,
you, Donovan.
Joey.
Thank you.
Thank you. Next question. Whose hand is up?
Good evening, Advocate.
Good evening, sir.
Yes, on that example of the accident in Klerksdorp,
yes,
what would have been a situation if the truck was coming from one of our neighboring countries, say from Zimbabwe, and the owners or the company of that truck, they don't have an office in South Africa? What will be the issue as far as the jurisdiction is concerned?
You attach the truck to established jurisdiction.
Okay, thank you.
Do you want to know how it's practically done?
Oh, yes.
All right. The first thing that you have to establish is where they have jurisdiction. If they don't have, if they are South African, first of all, and if they tell you no, we are from Zimbabwe, we don't have offices here, we just drive here and back every day. Your first question will be, your red flag will be, how am I going to get my clients money out of this? Because if they leave with this truck, my client's not going to have a right to sue them. So you very quickly run to the magistrate's court. In this case, you will not be relying on the value of the truck. You'll be relying on the value of the damage to your motor vehicle. And you tell the court the cause of action arose here in Klerksdorp, and I want Klerksdorp to give me an order to attach this truck from moving from here until I have now I've established jurisdiction. So now I can sue this trucking company now. And you'll be able to get you'll be able to get an order of attachment on an urgent basis in those circumstances.
Okay, thank you so much.
Pleasure, sir. Sasha?
Sorry, Advocate, it's me again. Advocate, I heard a question from a colleague, Mr. Louis, earlier regarding a motor vehicle and the spoliation application pertaining to that. So what if, so now the owner is, you are enjoying you are in full enjoyment of the vehicle, but the vehicle is not yours. You are not the rightful owner of the vehicle. But now the owner takes back his vehicle, and you want to bring now obviously the spoliation application. But isn't that something to do with your the ownership, and won't that be a high court application then?
No, it'll depend on the value of the vehicle. But you may bring that application in the magistrate's court as well. It's a question of choice. Okay. Whether you want to go high court or mag court, you can go either way and you won't be wrong.
Okay. So no, it's got nothing to do with who the
ownership
status change or something like that.
Ownership is not in question in spoliation.